Shalom, shalom, and we're going to start a study here over an issue that was well brought up by someone, which I'm not going to even mention, but an issue that is the issue of a Moser. And we're going to take a look at a fascinating article written by Rabbi Michael J. Brody, an Orthodox rabbi, who discussed this issue of a Moser, which is basically a person who's an informant or a person who's turning over a Jew to the secular government or non-Jewish people. Now, this is according to Jewish halakha and Jewish issues, and it has also a big major issue dealing with the secular government. Informing on others is considered being a Moser. And as we're going to see, the Rambam classifies there are three basic things that can be done to a Moser at the time in which he's about to inform anyone can kill him. He can be ostracized from the Jewish community, and he loses a portion in the world to come. So informing on others for violating American law in the Jewish view is something that we need to take a look at, especially of a lot of situations here in American law. Now, the classical Jewish law and informing on a fellow Jew is something that we'll look at. Also informing on people when government is committed to procedural justice, and there are 5 contemporary decisors on this. And again, I'm basing this on an incredible article that was written by Michael Brody. The view of Rabbi Eliezer Yehuda Waldenberg, there's no prohibition to inform when the government is just, which obviously for some of the Haredi groups that is terrible, because obviously there's a lot of crime being committed under the skew of being religious and not informing. There's also the view of Rabbi Ezra Batzri that there are no just systems and therefore no just prisons, and therefore obviously it's not justified, and we'll take a look at even his point of view, and where it is there's a license that's in the question even at that point. We're going to also look at the view of Rabbi Yitzhak Shmelki's informing as a tort in just government, and also the view of the Satmar Rabbi Shmuel Wozner, informing is permitted when Jewish law recognizes secular law as valid. We're going to also take a look at the Posek Hador of the Ashkenazi community, which is the view of Rabbi Feinstein, and the breach and the prohibition is unchanged by a just government. Of course, we're going to also take a look at some of the hypothetical conclusions that Michael Brody brings about. Now, the article addresses the questions of whether and when Jewish law permits or prohibits a mandate. Again, by no means am I being credited with this teaching as my own. It's not. It is available for free and available for dissemination on the internet. But I think it's very important that viewers can watch this, because not everybody are readers. And Jewish law prohibits mandates that a person informs government authorities on the fact that a Jew is violating one aspect or another of secular law. In particular, this article will focus on the application of the classical rules of informing Masira to modern-day America with its procedural justice system of government. Besides this, this area also is divided in 3 sections. The first briefly explains the central principles related to informing and summarizes the halakha that is found in the Shulchan Aruch and decisors or poskim. Second, the section explains or explores the various positions taken by modern decisors in regards to the prohibition to inform when society and government are just. The conclusion presents 6 hypotheticals, according to Michael Brody, that concerns informing in a just society, and notes the various views taken by modern posek on them. There are 2 initial points that need to be made to provide a certain amount of background and what would be considered relevant to Jewish law. First, informing is itself not sufficiently precise translation of the Hebrew term, and that is of concern of this particular lesson as well. Jewish law discusses 3 different problems of when it has to do with informing a bandit that a person has money or of some other item of value, informing of an abuse of government of the same, informing the government that someone has violated its laws, as it is obvious that to anyone even a vague familiarity with the flow of Jewish history, Jews have generally lived in situations where governments was unjust or unjust towards Jews, or bandits formed in the basis of government, and telling the abuse of government that a Jew had money or that the Jew had broken the law and was a dangerous act. Indeed, this conduct clearly and readily directs caused people to have their money taken, themselves beaten or tortured, and sometimes simply murdered. Now, I want to take a look at this because this took place. Also, an issue that is very relevant to Jewish history, in particular one which also crosses a co-religiousness, which is Christianity, and this is the issue of the betrayal of a Jewish leader of that time, a rebel by some, and that we'll take a look at this law in particular because it was in effect even during the time of Jesus in the first century, in which of course the big libel against the Christians and towards the Jews is the fact that they basically killed their Messiah, which we will take a brief look into that because there's a relevant connection there, because obviously, as we know, one of the things that is issued there is that the the leadership, the Sadducees had turned over, the religious body had turned over a Jew over to the Roman government. And this becomes an issue that's exactly at the point of this discussion. And the question is it permissible in order to turn a Jew over to save the rest of the Jews? And this is the concept that is being brought about here. So this article in particular, and this discussion, focuses on how these rabbinic decrees affect people, especially when money is taken, themselves beaten or tortured, and sometimes simply murdered. The Talmudic sages had no choice but to enact rabbinical decrees prohibiting such informing. And keep in mind, these are rabbinical decrees. These articles focus on how these rabbinical decrees affect people and conducts in a just government, where government only acts to punish the lawbreaker. Secondly, as will become very clear, this article and this discussion is a proper response to violent criminals, or people whose conduct endangers other people's or the community as a whole. In other words, I would even allege, I even know some rabbis whose conduct is very dangerous to the general community, should be removed from office, be removed as a rabbi of the community, because there is mental instability in such persons. For the sake of public safety, it'd be best well served if that person or those persons be removed from such position as rabbis. Baruch atah Adonai Eloheinu melech haolam she'hakol nihiyeh b'dvaro. Even in an unjust society, it was clear that one must bring such people to the attention of the secular authorities, if that was the only way to get them to cease violent ways. This whole entire lesson also discusses the problems of informing as it relates to the violators of the non-dangerous law or non-violent or regulatory laws, from cat burglars all the way to tax cheaters to zoning violators. Let me say that. Zoning violators, which I know a couple of one was involved in that one as well, and prescription drug abusers. This article is not discussing serial killers or armed robbers or sexual predators or muggers, for they must all be informed upon if that is needed to protect the society. So in other words, there's a big exception even in this law, that if a person is a sexual predator, and again, let me make a little cough hint regarding that, or they face to be a danger, a predator for the community, they must be informed upon. Now, let's take a look at the classical Jewish law in informing and an overview of that. Even though Jewish law expects people to observe the law of the land, and even imposes that obligation as a religious duty, the Talmud recounts a number of places that it is prohibited to inform on Jews, to the secular government, even when their conduct is a violation of secular law, or even when their conduct is a violation of Jewish law, where there are a number of exceptions to this prohibition, which are explained further in this teaching. The essential halakha was that Jewish law prohibits such informing absent specific circumstances. Even if secular government were to incorporate substantive Jewish law into secular law and punish violations of what is in effect Jewish law, Jews would still be prohibited from cooperating with such a system. Indeed, classical Jewish law treats a person who repeatedly informs on others as a rodef, a pursuer, who may be killed to prevent him from informing even without a formal court ruling. We're talking about court ruling as being a bet din, not a secular court, obviously. The prohibition of informing derives from 3 different Talmudic incidents, whose central theme is that of informing on a Jew, so that others take the property of the one informed upon is both prohibited and tortious. One, the Talmudic incident clarifies that the act of informing causes one to be the formal status of a pursuer, whose life may be taken to prevent the act of informing from occurring. In other words, once the person is known to be a pursuer, one can take they call action against their life to prevent the informing from occurring. But after the informing has taken place, that action cannot be taken. The reason for this rabbinic decree positing the informer, a Moser, is a life-threatening pursuer, a rodef, is simply stated by Rabbi Asher. One who runs to inform so that Jewish money is given to a bandit, anas, is analyzed analogized by the rabbis to one who is running after a person to kill him. This is seen from the verse of Isaiah 51 verse 20. Your children lie in a swoon at the corner of every street, like an antelope caught in the net. Just like when an antelope is caught in the net, the hunter has no mercy towards it, and so too the money of a Jew. Once it falls into the hands of the bandit has no mercy on the Jew. They take some money today, and tomorrow all of it. In the end, they capture and kill him, and since perhaps he has more money, thus an informer is like a pursuer to kill someone, and the victim may be saved at the cost of the life of the pursued. Excuse me. According to Rabbeinu Asher, what makes informing worse than any other act which improperly damages another Jew is that the informing puts a person in danger of life and limb. Even when the initial act of informing is over a small money matter, once one is enmeshed with these types of people, one can never tell what will happen. Even death can result. Thus, one who informs is like a pursuer who might kill. And let me suggest this, that even a person who may be even just slightly accused of being an informant is basically becoming, to a certain extent, like the one he's informing on. In other words, a rodef. So keep this in mind, because unless there are certain facts in existence where there is no doubt, that person may be acting as a rodef. Thus, Mordecai states that the matter is a little bit differently, and he writes, even though as a general matter we do not push into the pit to kill any tortfeasor, even a thief or an armed robber, the reason an informer is different is that the pagans gain and the Jews lose through this conduct. This is disgusting, and one who regularly trains himself to engage in such informing to pagans, his status is worse than other tortfeasors. Now, pagan is a very specific legal term that refers to non-Jews who do not believe in one God. So keep this in mind. This is not speaking of Noahide who believed in a system of justice. So keep this in mind as we're looking at this. According to Mordecai, informing is different from any other act which damages another because the rabbis decreed, and it is this whole issue of Moser is a rabbinical decree, It does not come necessarily from the Torah, although you may find some inference from it. But his informing is different from any other act which damages another, because the rabbis decreed that a person who regularly involves himself in ensuring that Jews losers and Gentiles improperly gain is engaging in an evil activity and forfeits his normal right as a Jew. A complete review of the rules related to informing is both complex and really beyond the scope even of this shiur, but a simple understanding of the nuanced rules is needed to understand why just government might be different. 8 sets of rules can be given. That outline is a general approach of halakha, which it takes. Now, why do we talk about a secular government whose rules are just and it pursues justice? Because, like it or not, everyone who is considered a citizen of such a state has to abide by the same rules, the rules of the Medina, and thus any of its citizenry, with exception of religious beliefs, are judged under the same law, which means it does not matter if the person who stole, who cheated, who evaded is a Jew, a Muslim, or Christian, or an atheist at that will. It abides upon all. It is prohibited by Jewish law to inform on a fellow Jew to a Gentile, whether the act of informing is about monetary matters or physical security. One may not inform on a Jew, even if the Jew is sinful and a bad person. One who informs is liable to pay damages, and if his acts of informing damages another. As a general rule, one is not liable for torts done to another by a third party. Informing is an exception to this rule. Even without the order of a Jewish law or a Jewish law court, one may kill a person who has certainly set out to inform on another prior to the act of informing, as informing poses a danger to the one who is informed upon. Once a person informs, one may not kill the informer as punishment for his sin. Let me say that again. One may not kill the informer as punishment for the sin, and one may not steal from an informer unless taking his property will stop him from informing. One who regularly informs may be killed without a warning. Now, obviously, how do you know that he is informed? Here becomes the issue of facts, and when there is a lack of facts, there is a lack of proof, and thus you cannot prove that in fact the person is informing. One who troubles the community through misconduct may be informed upon. So too, one who engages in conduct that endangers members of the community may be informed upon. One who hits other people and otherwise engages in acts of violence against people may be informed upon. So, in other words, those who accused of informing may themselves, if they're seen to be as a bully and have done harm physically upon other people and people close to them, may also be abided upon the same issue and may be informed upon. In other words, you have a person who's an abuser, a husband abuser, you can call the cops and have him arrested. You know, a person who has a violent temper, whether it be a Jew and he's going to harm a whole group of other Jews, you can call the authorities. So please, let's take a look at this a little bit further. When a Jew owes money to a Gentile, and when a Jew is seeking to improperly avoid payment of money to the Gentiles, and another Jew informs the Gentile of this fact, who then collects the money rightfully owed to him, that is not called informing, as Jews who inform upon only has to pay what ought to be paid anyhow. In other words, here we have an incident where you have a situation, put an example, that the Jew owes the other Jew money for work done and basically transgresses the law that you should pay the laborer when he is to be paid and does not. That Jew can contact and let the authorities know of the violation of paying the laborer his wage. And that is a just system, and thus that is not considered being a Moser in any means. Just the opposite. It is collecting the money that's owed, rightfully so. Payment of taxes to the government is exactly such a debt. Some say that such informing is frowned on when it gratuitously benefits a pagan. Okay, in some cases it's not benefiting a pagan, it's benefiting the Jew that their salary was not paid. And believe me, there are some religious Haredi communities, which I will not point any fingers at, that has a tendency not to pay their employees, that not to pay their workers when it's supposed to be paid. A rule that according to Torah is a major violation, because if that employee cries out to Hashem, Hashem will listen to their prayers. And thus, in that situation, such an employee can go to the Labor Department and complain, and file a legitimate complaint against the employer, whether the employer is working for a Jewish entity or not. All agree that when such a conduct leads to a desecration of God's name, it is prohibited to decline to report such a person. In other words, when the conduct and behavior of such groups of people or persons is such that it's a great desecration of God's name, for God's sake it must be reported, so that justice is meted and the non-Jewish people would realize that our laws is a just and rightful law. In other words, this idea of covering up all kinds of crime which creates a desecration of God's name is not justifiable, and it has no meaning or bearing of being called a Moser. Just the opposite. When a person takes action because Hashem's name is at risk in such desecration, it is completely permissible to inform. Now, I want to state point blank for this videotape, I by no means have ever done any such informing, and those who would say I did are falsely accusing me. And not only that, there is no proof in the records. But those who basically owed me money and did not have access and knew that they were not going to pay me, obviously there are means in which every Jew as well as every citizen has access to make sure that they are paid their fair wages. A Jew who is threatened with physical harm unless he informs on another is not called an informer. If he delivers information, he is not liable for the damages called. There is a dispute as to whether such conduct is proper or simply immune from liability. There is a dispute about whether a Jew who is threatened with economic harm unless he is illicitly informed on another is called an informer or not, whether such conduct is permitted or not. Now, many authorities rule that no liability is present if one informs on another to save one's own property without gratuitous intent to hurt the other person. Now, taking this at face value, the rules would prohibit a person from calling the government authorities when he is aware of illicit activity by a Jew unless the informer is himself under duress to inform, or the criminal is violent or threatening of the community, or according to some poseks, the informer does so to protect his own property. In case of a desecration of God's name, informing is also sometimes permitted. These rules, by their simple, direct application, will prevent a person from informing on his neighbor who is cheating on his taxes, since the government imprisons such people and does not merely retake the money owed, violating non-safety related zoning law, stealing cable television from the cable company, and a host of other violations of American law, informing on a serial killer or mugger or assaulter or abductor. In other words, when a person, in particular a Jew, takes a child whose custody is under their mother's custody or father's custody against the will of the physical parent, and decides to take them out for a trip against their wish, that person basically can be informed on and have that person arrested for violating the civil law as an abductor. a child abuser or any other violent criminal would be also permitted. Now we're going to take a look at such other governments and other different rules, because one of the things that there's a tendency to take place in the religious community, Haredi or Hasidic community in particular, is that they protect a lot of the abusers, a lot of the child molesters, pedophilia. People may think that this is not a big rampant problem. One of the known and well-known therapists in our community, Dr. Feldman, had informed me some time ago that over 10% 10% of the Hasidic and Haredi community in New York is plagued with this problem. Plagued with this problem. So imagine what we're talking about when we're talking about informing. And of course then the Jewish community and the parents are completely tied, because they don't want to inform on a fellow Jew, especially rabbi, that their behavior and conduct is not only immoral, but when discovered, it is a desecration of God's name. My friends, the law was there to protect and serve. It's a just law. We're not snitching on a fellow Jew to basically get them back or revenge. It's there to protect. As a matter of fact, there was an incident about 2 or 3 years ago that I contacted a particular rabbi in the community over the same issue, Rabbi Weberman, and he gave me the green light. They said, you know what, you have to protect the life of a human being. You have every right to not only call and inform, but let others know about it. In other words, this issue to inform and put pressure so the person would stop his misconduct. And let me say that again, his misconduct. There's no justification for such a misconduct, especially from a leader or rabbi from the community. Now, how do the halakhic rules of informing apply to a just government of laws with non-discriminatory laws properly enforced by police who obeys the laws and who punish people in accordance with its laws, is the question that we're going to address now. This section makes certain assumptions about the nature and operation of American law that needs to be stated, and this section is predicated on this assumption. There are at least 4 specific assumptions that are posited in this section about the nature of American society and its government. The American government of the United States of America and various states in the government units are just and proper governments that do not, as a general matter, punish people beyond the dictates of secular law. They are not corrupt governments. Governmental actions are not generally motivated by anti-Semitism, and the conduct of governmental officials is not anti-Semitic. As a matter of fact, American law, people cannot be compelled to go to a Jewish law of court to resolve their claims against them if they do not wish to submit it to a bed din. In other words, in one other case that I had against a gentleman who basically had approached my organization and had fraudulently skimmed the monies off people who were going to learn with our organization, and when I brought it to the bed din here in Florida and also in New York, they gave me the letter to go ahead and pursue, and I advised the community of this, and they ignored it. And until this person began to steal and do everything, they began to take notice. Unfortunately, everything is swept under the rug, especially under the Hasidic umbrella or the Haredi umbrella. Everything is swept under there. Very similar like in the Catholic Church, that the issue of pedophilia was basically covered up. I think we need to wake up to the reality that something that is wrong no matter what religious position you may hold. According to American law, it's a violation of the laws of the land, and it should be prosecuted. Now, as a matter of fact, American law, Batei Dins, are unable to adjudicate matters that require physical punishment, incarceration, restraint of people, and cannot respond in an emergency situation when force is needed, unlike during the period of time of Rome. When Rome had occupation, the Jews did not have the power to adjudicate incarceration and physical punishment or death penalty. which was a case that you will see if those of you who have read the Christian Bible, the New Testament, was the case with Jesus, in which the leadership had informed the Romans of a violation of Roman law in order to put Jesus to death. And this is an issue that we'll take a look at in a few seconds here, where a group of religious Jews, even though they were not part and parcel, had turned over a fellow Jew in order to take care of the problem as a rebel rouser, as it were. And so we find here that although Jews did not kill Jesus, in fact, they did turn him over. And this is not, even in the Talmud it makes reference to that, they basically was turned over. As will be shown throughout the section, disagreeing with any one of these four factual points will frequently lead to significant changes in the applicable Jewish law of informing. And yes, we had informants, and we have a lot of records of how many Jews were also informed on to the Roman government, in which caused this whole entire rabbinical issues to be brought forward. Now, one additional point needs to be made about American law, and it's its impact in relevant Jewish law. As a general proposition, members of our secular society are not obligated according to American criminal or tort law to report violators to American law. In modern American law, unlike Jewish law, if one did not cause a violation or have some other special relationship either with the victim or the criminal, one bears absolutely no legal obligation to intervene to stop a crime or even call the police. In American law, one need not to report one's neighbor for tax fraud or call the police when one witnesses a crime or rescue a drowning person from a river, or even in the circumstance where Jewish law mandates that one not inform on the person who has knowledge on the criminal activity by another, and does not report it. It's not violating American law at all. However, once one is summoned to testify, or even questioned by a governmental official or government official, it is a crime to lie to a government official about the relevant matters. Now, there are no less than 5 different halakhic answers that have been presented with regards to whether the prohibition against informing applies to a just society. And these 5 views can be summarized as follows. The rule of informing have not changed at all. They are independent of the status of government as just or unjust. Informing is thus only permitted in the case of harm to others. In other words, you have a perfect incident. For example, those of you who were basically aware of the happenings of the Rubashkin situation, where witnesses came about of how many people were actually harmed by some of the actions that were taken against people who were both Jewish and non-Jewish. I'm not going to go into that in all details, but a lot of people were harmed. So in this such case, such a situation, that would have been permissible. The rules of informing have not changed. Now, an informer is not a pursuer anymore, but the informing is still a tort, and one who informs on another without cause is liable for the damages caused. Informing is tort, no different than damaging a person's property with a baseball bat. Now, even a just government behaves improperly sometimes and runs jails that are improperly placed, and the presence of even occasional improper behavior by government or its agents or its prisons justifies a prohibition of informing. Thus the rules of informing have not changed. There's no prohibition of informing to the secular government when the secular government is enforcing a law that Jewish law deems valid under the law of the land, or according to the obligation of Gentiles to create a proper system of dinim, law. In other words, is these laws in order to protect the general society? Are these laws safe and just? Are these laws there to protect all the members of that society? And we're going to see that most of these laws that were protected or enacted, when it has to do with even labor laws, when it have to do with even racketeering laws, and a lot of other laws that I can mention, is for the protection of the society. Imagine for 1 second, had a Jew knew about Madorf's scam before it arrived to the point where it arrived to. it would have been an incredible mitzvah to stop him, mitzvah to inform on him. Instead, they allowed him to go to such a level, because of obvious greed, to the point where his action caused literally a desecration not only of Hashem's name, but of the reputation of Jews in general, marring all of us with one stroke. So this is one thing that needs to be considered. Now, as has been made clear throughout this work of Rabbi Brody, which I think is a fantastic work, these 5 views are not discussing serial killers, armed robbers, sexual predators, neither muggers or similar violent criminals. They must be all informed upon that is needed to protect, and we've said that already. The view of Rabbi Eliezer Yehuda Waldenberg is no prohibition to inform when a government is just. The view that the prohibition of informing does not apply to a government that protects property right is generally governed by the law and order. It's articulated in Rabbi Yechiel Michael Epstein in his Restatement of Jewish Law in the Aruch HaShulchan. He states, as is widely known in the times of old, in places far away, no person had any assurance in the safety of his life or money, because the pirates and the bandits, even if they took upon themselves the form of government, it is known that it is true nowadays in some place in Africa where the government itself is grounded in theft and robbery. One should remind our people of the kingdoms in Europe, and particularly of the rulers of Tsar, which unfortunately a lot of the Haredi and those who does these accusations, they come from this system of government, and therefore they think this is still applicable in American law. And his predecessors in the kings of England, who spread their influence over many lands in order so that people should have confidence in the security of their body and money. This is the whole pursuit of life, happiness, and the pursuit of, life, health, and the pursuit of happiness, stated in the United States. The wealthy do not have to hide themselves so that others will not loot or kill them. On all of this, the presence of looting and killing hinges on the rules of informing, or Moser, or slandering, Malshin, in the Talmud and later authorities. As it will be explained, these rules apply only to one who informs another to bandits, so to endanger the person's money and life, and these bandits chase after the person's body and money, and thus one may use deadly force to save oneself. In other words, I would even be able to argue, based upon this, that any Moser in this government can defend themselves from an accuser of being a Moser. Interesting. The question of whether the writer of the Aruch HaShulchan really meant what he wrote, or he wrote it for the sake of censor, is a matter in dispute. However, Rabbi Eliezer Waldenberg adopts the view of the Aruch HaShulchan explicitly. In the course of discussing whether one may inform on a teacher who is molesting a child, Rabbi Waldenberg states, even in the understanding of the secular court system, it appears that there is a difference between primitive and enlightened government, as noted by the Aruch HaShulchan in Choshen Mishpat 388.7, where he states, every issue related to informing found in the Talmud and Poskim deals with those faraway places where no one was secure with his money or body because of the bandits and pirates, and those who had authorities, as we know nowadays in places like Africa. Such is not the case in Europe. Whereas in the Aruch HaShulchan, I write this as an annotation of a general importance in the matters of law of informing. The halakhic predicate for this view is that the repeated use of the term bandit, anas, throughout the many halakhic texts dealing with informing to be limited to a simple meaning. It is only prohibited to inform on people to bandits. The many different rulings limiting when one can inform on a Jew are limited to cases where people to whom you are informing are unethical, unjust individuals, or unethical and unjust government. The language of the Torah supports this idea. One who delivers another's money into the hands of the bandit, whether the bandit is a Jew or a Gentile, must pay damages that he caused, since he caused a loss of money. We're not talking here about loss of wages or unpaid wages or commissions. We're talking about here is taking the money, stealing the money of a Jew, and giving it over to bandit, and basically conspiring to do harm. A close examination of the words of Rabbi Asher quoted above does indeed indicate that this is the fear of improper murder or torture of the victim that caused this rabbinic decree. And let me emphasize it. It's a rabbinic decree. Rabbi Yosef Shalom Eliashev explicitly adopts this logic. The questioner asked him, the office of the religious affair and the location has been robbed and collected money in more than one occasion. All the indications points to one of the workers, but all our efforts have not led the person to confess. We're asking if it's proper to call the police, who after investigation, if successful, will bring the suspect to secular court. The matter could be serious, as we suspect that the person is the husband of a large family, and this person is connected to Torah activities. Here we go again. A religious person. Is it possible that there will be a desecration of God's name? Heaven forbid. On the other hand, the public money is missing, and who knows what else is gone. Here as we have the importance, and I'm going to say this as a parenthesis to those who may be viewing this, is the importance of accountability in these religious communities where I would even say that some of the monies are laundered, or money comes in, they go out, no one's accounted for. There's no accountability for what's taking place. Usually one person or two person handles all of the monies coming in and out. But I'm not going to open that box of worm here because it's already been opened before in other circles. But accountability becomes an issue on all different levels. But let's move forward. Rabbi Eliashav replied, Panim, in response to Panim Me'erot 255, dealing with our matters of one who found an open chest and much was stolen from there. There is a reasonable ground to believe that one of his workers did the act of theft. Is it permissible to inform the work on this to the secular authorities? He proves from Bava Batra 117 and Bava Metzia 25 that there is a religious duty on the judge on this matter to hit and punish based on the knowledge that he has. When his knowledge is correct, he then quotes from the incident of Rabbi Herschel in the view of the Shach, but he concludes, nonetheless, the author of the Panim Me'orot says that it is improper to report him to secular authorities, as her Talmud sages recount. They treat him like a caught animal, and one must be afraid that they will kill him. From this is clear that such is not applicable in our time, said Rabbi Eliashev. By the halakha, it would be proper to report him to the police, but you ponder the possibility that this will lead to a desecration of God's name, and it is not my ability to evaluate this, since I do not know the facts. This is said by a person, basically, a rabbi, a posek of the Ashkenazi community in Israel and throughout the world, that did not have all the facts, and you need to have all the facts. Now, this view posits that when fear of death or torture is functionally gone, the rabbinic decree prohibiting informing does not apply. This is true according to these authorities, even when the government has no right, according to Jewish law, to enforce this particular law on its Jewish citizens, or punishing them in a manner far beyond the permitted by Jewish law. And even applies when government is arresting an apparently innocent person, as the system as a whole is just and fair. Even non-violent criminals or people who violate regulatory directives such as zoning laws may be informed upon in this view. In other words, rabbis and Haredi Hasidim, you have zoning law problems, fellow Jews can inform on you according to this opinion. Now, what does that mean? Obviously, it shouldn't be done. Obviously, we try to work things out, but laws were made to be applied and enforced. If not, if we would not be a government of laws, we would be a government of confusion, disorder, and corruption. This approach posits the informing even when the government does, as a matter of fact, truth, use information provided by the informer to produce an improper result. It's not classical tort at all in the eyes of Jewish law, but was a special rabbinic decree prohibiting conduct that was not intrinsically tortuous, and that the rabbinic decree prohibiting informing was limited to situations of banditry. Thus, in situations where there is no prohibition to inform, there is no violation of Jewish law to inform. Any damage that is caused is not attributable to the informer, but to the one who does the damage. One of the things that people probably say is, well, poor guy Rubashkin who's sitting in jail, and I really feel sorry for his family and continue to pray for him. But the question among some of the Hasidim of Chabad is, who informed on him? How did he get this terrible thing? First of all, let me say this, not I, but if this person was causing an incredible amount of damage and was harming not only Jews but also non-Jews, I would think it would be a mitzvah to let the authorities know so they would put this into perspective. We cannot allow not even our fellow Jews to go against the law that is there to serve and protect the general population. Just does not make any sense. Not either was that the intent of the Rambam. But in some people's mind, you can justify this issue of Moser in order to be able to cover the tracks and to use it as a vehicle to bully and to hush and to pound those people who are in fact the victims of the criminals. Yes, the victims of the criminals, and both being Jewish. The views of the Rabbi Ezra Batri, there are no just legal system and no just prison. If I'm not mistaken, Rabbi Batri was originally from Iraq and lived in Iraq. Maybe I'm wrong. Someone could perhaps correct me on that. But Rabbi Ezra Batri, in his modern multiple volume of treatise on Jewish commercial law, Dinayim Amunut, responds to the view discussed in Aruch HaShulchan above. After stating the view that informing is prohibited, he also notes the following. Do not be surprised by the rules in this chapter and think that they are inapplicable nowadays, since governments are enlightened and democratic, a beacon for people to travel. They should be thought true of only by very naive, and even in democracies. In truth, when there is a matter that involves the government, the matter is treated out of normal protocols happen when matter relates to security of the state. All rules of informing are applicable, even currently. Anyone who knows and understands and sees not what is externally visible and what previously was, now keep in mind we're talking about rabbinically issued laws here, and see not only what is externally visible and what is previously was, will see that the only external appearance has changed, the outside has changed, but the central characteristics of government has not changed. And even they bring all matters to court, it's clear, through interrogation and police, government can destroy people in many places and do in fact destroy people. This is also true when it's done on a private level. Through Batei Dins that have no power of enforcement. Rabbi Batri posits that even when the external justice system seems to work, nonetheless the executive and judicial system is so deeply fraught with exceptions and extrajudicial misconducts and coerced confessions that one must assume injustice will occur, and thus informing on a fellow Jew remains generally prohibited as always. Let's take a look at another opinion. Rabbi Yaakov Yeshaya Blau, author of the multi-volume Petchai Chosin, raises a related point as a possibility. Even if the justice systems work up until the point of incarceration, nevertheless the punishment of imprisonment is analogous to the endangering of a person's life by informing on them in a way that endangers their life, since imprisonment poses the possibility of life-threatening conditions. Rabbi Blau proposes the possibility that even if a justice system works only to incarcerate people who are deserving of incarceration, jail is a most unpleasant place to be, with physical duress exactly of the type the Talmud would imagine, and thus informing on a person in a way that might produce a prison sentence is prohibited. Evaluating this type of claim is very difficult, but Rabbi Blau's observation has a certain amount of merit in this matter. One well-known commentator on prisons in America observed, Prisons, never safe places, are growing increasingly dangerous to inmates. The most recent Department of Justice research shows that 14% of all prison inmates and 20% of all those under the age of 25 have been assaulted while in prison. Now, according to Rabbi Blau, it is in prison where the halakha now fears that the observation of Rosh are correct. People are abused and tortured without any basis in law. If the approach of either rabbis, Batri or Blau, is correct, one divides cases of informing into three types of category. One situation occurs when a person is being informed upon as an individual who is violent, or threatens violence, or induces harms to others, or endangers the welfare of the community. Such a person may be informed on. In other words, even in this community, such accusations would not apply. In other words, if such a person is a person that was, like in the case of Rubashkin, or in the case of a child abductor, or in the case of a person being called on to protect the life and safety, I'm sorry, but that person can be informed upon, even though, as I mentioned before, from this person who's speaking, never informed. But it's interesting because we bring to the point that it could have happened. In other words, an informant could have come forward from the Jewish side. Obviously, we know that it wasn't a Jewish informant that brought down Rubashkin. It was a non-Jewish informant. Interesting enough. But this is things that has to do with facts, not allegations. Now, such a person may be informed upon as Jewish law recognizes the need to remove these people from the community, even if these people might be harmed by brutal prison systems. The second situation is that nonviolent criminal, white-collar crimes such as intentional bouncing checks or recreational personal drug use. But because the prison system might be brutal to them, Jewish law rules that one may not inform on them to the police because of the punishment imposed on them is unacceptable according to Jewish law. Now, the others of informing, such as parking violation, building code violation, unintentional environmental damage, and the like, where arrest and detention is not a possibility, would not be prohibited by this rationale. In the opinions of Rabbi Brody, this observation that the prisoners are sadly enough, and to the shame of our society, treacherous places for torturous conditions, incapable of punishing people justly, has a powerful practical logic to it, and seemingly has a powerful persuasive element as well. If American society cannot run a criminal justice system that punishes non-violent criminals properly, Jewish law should not be an accomplice to a criminal system, a criminal justice system that in fact brutally punishes people for non-violent offenses. Now, the view of Rabbi Yitzchak Shmelke informing as a tort in a just government. Rabbi Yitzchak Shmelke advances a novel answer to the question of informing in a just society. He states, as you wrote, on the central matter of one who informs about monetary matters nowadays, such a person does not have the status of a pursuer, as there is no fear nowadays that such informing will lead to danger to life, and certainly such a person is not ineligible to serve as a witness according to Torah law. According to Rabbi Shmelke, one must make a factual determination as to whether informing can lead to life-threatening conditions. If it can, then informing leads to one being classified as a pursuer. Otherwise, such conduct is generic tort, and while damages have to be paid, one is not considered a pursuer, a rodef, because of such conduct. Thus, there is no claim here. One might be even deemed a sinner, but merely a tortfeasor. Similarly, such as view is similarly endorsed by Rabbi Yaakov Yeshaya Blau, writing in Petkai Choshen, who states, in the writing of many decisors, we have seen that they found some merit, lamdu, zechut, on the kings and governments of their time, and that rules of informing did not apply. But it is widely known that in these kinds of work, the hands of censors is present. In circumstances, they wrote or left out matters out of fear of censors of the government, or at least because of the hatred of the Jews, Iva, and thus hard to learn from these sources. Nonetheless, in my humble opinions, there is an acceptable aspect of this view that informing does not apply in just society, since the essence of the prohibition to inform, even on monetary matters, is lest they come to kill you. It is clear that in a country where the government is just, even though the informing is clearly prohibited, nonetheless there is no fear that they will kill you. Thus an informer is no different from any other damager of property of another, and none of the strictures concerning informing, which can result in physical duress, applies. Interesting enough. To understand this view, one must accept that there are really two distinctly different components to the rules of informing: the tort component of damaging another, and the sin of endangering the life of another through informing. In a society where in fact there is no danger of life and limb through the informing to the governmental authorities, the informer loses his status as a pursuer, according to the view of Rabbi Shmelkis. Indeed, although Rabbi Shmelkis does not state so explicitly, when only the tort prohibition is present, the only reason informing is prohibited is because one is improperly damaging the property of another. Absent the danger, both economic and physical informing becomes merely tort. It is unusual to tort according to Jewish law in that the causation the causation is indirect, but would be the essence of remaining rabbinic decree. The informing on another improperly creates liability according to Jewish law. In fact, the halakha does not become much more complex, the halakha does become much more complex in that once informing is treated like any form of damage, it becomes permissible to engage in informing at any time damaging another is permissible. Thus, for example, consider the case of one who improperly disposing of waste oil into another's backyard. If this person's misconduct did halakhically recognizable harm to another, and that person needed to abate the harm being done to him, he could call the relevant governmental organization, which would issue the suitable regulatory remedy. However, according to the rationale of Rabbi Shmelkis, if one simply called the relevant authorities, in such case which there is no harm to oneself, such action would be prohibited according to Jewish law, as it would be causing damage without any right to do so according to Jewish law. Now one would then be liable for full damages one did, including the liar's fee and the like. Now let's take a look at the view of Rabbi Shmuel Wolzner, which is a Satmar rabbi, more Hasidic in his view, and see what he says on this matter. And I do correct myself. I believe he's a Lithuanian Jew, so I may be incorrect regarding referring him to as a Hasidic rabbi. Now, the view of Rabbi Shmuel Wolzner, informing is permitted when Jewish law recognizes secular law as valid. Another view relates to the prohibition of informing to the legality from the perspective of the Jewish law of the secular government's action. In this view, informing is prohibited only when the government seeks to enforce secular law, and the Jewish law does not consider obligatory upon the Jew, according to Jewish law. Consider, for example, Rabbi Shmuel Wolzner's discussion of whether one may work as a tax auditor for the government, especially our new IRS government, that they're looking at every single citizen, everybody to the right. In the matter of one who works in the tax office, and when one sees one who defrauds the government, he has to report to the court. The person wants to know if if his status is that of an informer, or the law of the land is the law and is thus proper. And it is clear that according to halakha, taxes without dispute or controversy are covered by the obligation to obey the law of the land. On the question of informing the government, it is clear that from the incident discussed in Baba Metzia 83b with Rabbi Eliezer, who informed upon a person to the government that this conduct was permitted because of the loyalty to the government, even though they said to him, "How long will you hand over God's nation to be killed?" This is because the matter relates to the danger of a life of a Jew. So too, which Elijah recounts on Rabbi Yishmael, that he should cease informing is applicable, but the technical halakha appears that this matter has a benefit to the government. See the Rama regarding Choshen Mishpat 388:11, who knows that if one wishes to flee to avoid paying the Gentile what he actually owes, and another reveals this information, the latter person lacks the status of an informer. Even though the Ramah concludes nonetheless bad was done, it is as analogous to returning the lost object to a pagan. Thus, it's limited to the returning the lost object to an individual pagan. However, that which is relevant to the government is in its designee. There is no sin, neither of informing or returning the lost object improperly. Nevertheless, ab initio, it is better not to accept an appointment to engage in such activity, since it entails informing on even in a permissible way, which is not the conduct of the righteous, as noted in the Yerushalmi Talmud in Teruma 8:4. Furthermore, this case is not analogous to other cases, as those cases involved danger to life. As those cases involved a danger to life, and is formed in this case is different because punishment imposed on the violator nowadays never involves mortal danger. Now, in this view, informing is a violation of halakha only when Jewish law does not recognize the inherent validity of the right of secular government to enforce its action through the law of the land. Whether the conduct one is reporting violates the autonomous Jewish law, absent secular law, is completely irrelevant in this mode of analysis. Whether the person is punished in a matter of consistent with Jewish law or not does not matter, because Jewish law only prohibits informing when Jewish law is invalid in the eyes of the Jewish law. In the opinion of Rabbi Brody, this approach is broadly predicated on the concept of the analysis of Rashi, commenting on the Talmud, who seems to accept that Jewish law recognizes secular government and may be properly enforced any law of validity promulgated under the rule of law of the land, dina de malchuta dina, even against the Jew, as a function of law creating dinim, obligation imposed on Gentiles. Maintaining such functions, as is collecting taxes, indeed, once one accepts that Gentiles are empowered by the Noachide laws through the commandments of dinim to make and enforce laws, it is not far a leap of logic to observe that such criminal laws once made are binding upon Jews, to the extent that Jewish laws does not mandate a different result. If that is so, then the Jewish community may assist in the enforcement of Noachide laws without stepping afoul of the rabbinical prohibition of informing Masira. Now, we have much more to go, and I'm going to pause right here because there's a lot more in this article with Rabbi. Let me see how much more do we have to go here. It's a very, very thorough article, and I do invite you to read this article at jlaw.com. That's jlaw.com, articles from Michael Brody, and incredible law articles. And I hope you have enjoyed this, because even though it's been about an hour, a lot of the arguments, and to summarize a lot of this, by and large, even with Rabbi Feinstein's prohibition, which is unchanged, each one of these, to a certain level, allows that the secular authorities have a right to be able to govern criminal actions. And even if a Jew that's involved in informing, there are areas in which it's allowable. So, in the United States, in reality, the issues of being a Moser really is not at all something that in many cases is applicable. And there are certain points which it is applicable. But in the majority of the things, a person owes you money, go to the Labor Department. It becomes an issue of tort. And in tort, most Batei Dinim in the United States don't deal with it. And if they do, a lot of them have been, let me say it this way, bought by one party or the other by giving tzedakah to the dayans. And this is the reality of our situation here. So, unfortunately, in this study we learn one important thing. Moser, we don't do. But there are cases in which you have to do it, because it's an issue of not allowing Hashem's name to be desecrated. And this should tell every single Jew, religious or not religious, Hasidic or not Hasidic, that you got to live by the laws of the land, my friend. You can't just decide to let a child molester go because, after all, maybe he's a Chabadnik, or maybe he's a Hasidi, or he's a Jew. If he did something wrong, he needs the help and intervention. He needs to be taken care of, and he needs to be treated with. But don't sweep the problem under the rug and think it's just going to disappear on you. My friend, that's not going to happen. This is why we have so many people, so many rabbis behind the pulpits that have swept so much garbage under the rug that it's a mount. It's a mountain of garbage that has been built up. And hopefully this video will help have the merit to start taking out the garbage and start dealing with the garbage on the individual level, on the personal level. And hopefully by this, the intranet Lashon Hara and Motzi Shemra would end. I doubt it. That's why Mashiach hasn't come yet, because what appears to be unity is plagued with complete frock. It's sheker. It's a sheker unity. And unfortunately, I'm sorry to say that, it's sheker. Shalom, shalom. There is hope. You don't have to be a Moser. Shalom.